We've gone through this before, but I'm just going to reiterate the statute you need to look at when it comes to security deposits.
Hi guys. This is pretty much been Jonathon Daily.
Let's go to the review on security deposits. So key points here: Florida Statute 83.49 is the statute you need to look at when it comes to security deposits. Lease is up, you vacate. If they're going to return the full deposit, they have 15 days to send it to you. If they're going to impose a claim on it, then they have 30 days from when you vacate or when the lease is terminated to send you a certified notice, a certified mail notice imposing a claim on your security deposit. I'm going to get into this later about how they can actually do it by email now, but that's a separate issue. For now, 30 days to send you that notice. But that notice is important because it really needs to have specific language in it that says you must object within 15 days. And if you don't, just put you on notice that if you don't object, that they are going to withhold the security deposit, and you pretty much lose your right to object at that point. So if that language is not in there and it's in the statute, go review it. If that language is not in there, then arguably they did not substantially comply with the notice requirement and they should return it. Does that mean they will? Just because you put an objection, hey, you didn't put the language that is substantially complying with the statute? No. A lot of times they won't. Maybe you'll have to go to court. Maybe you'll have to file small claims, whatever it is. Call us if that happens and we'll help you out. Last thing on security deposits here. If you do vacate early prior to the termination of your lease, it's important to understand that that does waive the notice requirement for the landlord. So if you vacate early prior to the actual termination of your lease agreement, you need to provide a forwarding address if you have a chance of getting your security deposit back. If you don't, then that does waive the notice requirement from the landlord. So don't expect to get it back. That's also for you landlords out there. Get a lot of calls from you guys. If they vacate early and the tenant does not communicate to you and provide specifically a forwarding address, then most likely you do not have to provide that notice. Again, your lease agreement could change things a little bit depending on the situation, but for the most part, if they vacate early, don't provide a forwarding address, which they often won't, you can withhold their deposit and you do not have to send them a notice imposing a claim on the deposit. So hopefully that makes sense to you guys.
For the latest in case updates, legal tips, news, and politics, make sure to like us on Facebook, follow us on Instagram and our other socials, and above all, subscribe on YouTube to get your dose of excellence on a daily basis.